jury has a verdict. Are we ready for the jury?
Yes, sir.
We are.
Yes, sir.
Let's bring the jury in, please. All right, jury back, please be seated. All right, Madam Foreman, my understanding you reached a verdict, is that correct?
We have, Your Honor.
Could you please present to the deputy, please? Clerk, would you please publish the verdict? Yes, sir.
You want the defendant to rise, Your Honor?
If he wants to, doesn't have to.
In the Circuit Court, Unit 4, Escambia County, Florida, State of Florida Plaintiff versus Donald Wayne Hartung, Defendant, case number 1715 CF 004806A, Division C, Danheiser. Jury verdict form, death penalty. We, the jury, find as follows as to Donald Hartung in this case. Section A, aggravating factors as to count 1, Voncile Smith. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the defendant was previously convicted of another capital felony. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed for pecuniary gain. No. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed in cold, calculated, and premeditated manner without pretense of moral or legal justification. No. Aggravating factors as to count 2, John Smith. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the defendant was previously convicted of another capital felony. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed for pecuniary gain. No. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed in cold, calculated, and premeditated manner without pretense of moral or legal justification. No. Aggravating factors as to count 3, Richard Smith. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the defendant was previously convicted of another capital felony. Yes. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed for pecuniary gain. No. We, the jury, unanimously find that the state has established beyond a reasonable doubt that the first-degree murder was committed in a cold, calculated, and premeditated manner without pretense of moral or legal justification. No. Section B, sufficiency of the aggravating factors as to count 1, Voncile Smith. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, Section A, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Yes. Sufficiency of aggravating factors as to count 2, John Smith. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, Section A, we, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Yes. Sufficiency of the aggravating factors as to count 3, Richard Smith. Reviewing the aggravating factors that we unanimously found to be established beyond a reasonable doubt, Section A. We, the jury, unanimously find the aggravating factors are sufficient to warrant a possible sentence of death. Yes. Section C, mitigating circumstances. One or more individual jurors find that one or more mitigating circumstances was established by the greater weight of the evidence. Yes. Section D, eligibility for the death penalty for count 1, Voncile Smith. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt, Section A, outweigh the mitigating circumstances established in Section C above, As to count 1, Voncile Smith, no. Eligibility for the death penalty for count 2, John Smith. We, the jury, unanimously find that the aggravating factors that were proven beyond a reasonable doubt, Section A, outweigh the mitigating circumstances established, Section C above. As to count 2, John Smith, no. Eligibility for the death penalty for count 3, Richard Smith. We, the jury, unanimously find that the aggravating factors that were proven beyond reasonable doubt, Section A, outweigh the mitigating circumstances established in Section C above. As to the count 3, Richard Smith, no. Dated this 7th day of February 2020 in Escambia County, Florida, foreperson Jennifer Cassard.
All right, please be seated. Are there any requests of counsel?
No, Judge.
All right. Members of the jury, we all appreciate your extreme dedication. There's no more serious or draining case for a jury than a case of this nature. We've taken the better part of a month of your lives, and we understand the sacrifice you've given, but it's necessary for the judicial system to function properly, and our due process guaranteed by the Constitution to process properly. So I want you to understand that your sacrifice has been meaningful, and we in the whole community appreciate that. At this point, you are free to discuss your participation in the trial. Of course, you do not have to speak about it at all. That's completely up to you. You will have, the deputy, do you have the excuses if anyone needs excuses for work or whatever, the deputy has copies for you. And again, I guess for the last time, with our thanks and great appreciation, you are hereby excused for the evening. We hope you have a very nice week. Thank you again. All right, please be seated. Is there any reason that sentence should not occur at this time?
Not from the state.
Any input from the state?
Judge, I just would ask that you run each count consecutive. The state is also asking for $4,000 cost of investigation to the Escambia County Sheriff's Office, and I would just request that that be reduced to a lien.
What are the fines and costs for these charges?
I have no idea, Judge.
$518.
One, 518?
$518. Yes, sir.
All right, any input from the defense?
No, Your Honor.
All right, this time the jury having found you guilty, I'll adjudicate you guilty of 3 counts of first-degree murder. I will sentence you life in prison on each count consecutive to each other. There will be $4,000 investigative cost imposed, which will be reduced to lien. 518 court costs, which will be reduced to lien. You have 30 days to appeal the sentence. If you can't afford an attorney, one may be appointed for you. Anything else before we wrap up?
Not from the state.
Okay, that's the judgment and sentence of the court. You have 30 days to appeal the sentence. If you can't afford an attorney, one may be appointed for you. And I want to let counsel know you all did a very exemplary job, and I appreciate it. Just questions.
Excuse me, Judge, just for the record, if you would find Mr. Hartung indigent for the purposes of appointment of a public defender, we'll file a notice of appeal, but if you would allow us to withdraw on the filing of the notice of appeal.
That'll be done.
Thank you, Your Honor.
As far as time served, that showed 1,565 days.